Last week, Nigeria breathed a sigh of relief after the commercial court of England and Wales halted enforcement of an $11 billion Process and Industrial Development Limited arbitration award against Nigeria. Justice Robin Knowles held that the company's award against Nigeria was obtained by fraud. Nigeria may have escaped paying such a humongous debt for a job not done, but moving forward, there is a need to ensure that the country does not enter into such fraudulent contracts. We have in our studios Dr. Chikwendu Madumere is the trustee representing Africa on the board of trustees of the Chartered Institute of Arbitrators, UK, and immediate past chairman of the Chartered Institute of Arbitrators, the Abuja chapter. Very warm welcome to Newsnight.
Thank you very much for having me this evening. And good evening to our viewers.
Yeah, the entire corpus of, the case is well known, but as an arbitrator, what lessons should we take out of this? Because I'm sure there are many contracts out there of international dimension that, Nigeria might just be in the process of signing.
Well, I think the starting point should be to re-echo the sentiments that you expressed earlier on to congratulate Mr. President and the Honorable Attorney General of the Federation and the entire, team of the federal government for the principled position they took and for the commitment, in seeing to the victory that we enjoyed in this matter. That principled position, for me and for most stakeholders, in the arbitration business, is actually a loud statement that we have made, and that statement resonates across the globe. That it's no longer business as usual for Nigeria, and that it's no longer business as usual for unscrupulous investors and business people seeking to take advantage of our jurisdiction.
You must add the government officials there, because we're still going to talk about that. Some people are known to have orchestrated that deal. One of them we hear is even dead now.
Well, I think that would form, a part of my contribution to this, to our discussion.
Great.
And I think the starting point for me is to congratulate and to, the government over what has happened. In my language, it's usually said that you chase out the enemy first before coming in-house to reassess what has happened. So now that we have, obtained victory at the commercial court, the question then is, what can we do in-house to ensure that this kind of situation do not arise again in the future? Are there things that we could have done differently that could have stopped all of this, from happening? For instance, our procurement processes in-house, could they have done it differently? And when you read through that judgment over and again, you ask yourself a lot of questions. I mean, how was it possible that we could have signed off on that contract, gas processing contract? And as you know, gas, a lot of it is in the hands of the IOCs. Mm-hmm. None of them was a part of that
contract
process. So who was supposed to supply the gas? What about the infrastructure?
Conveying the development,
gas? Yeah. Exactly. So who was supposed to do all of that? So how come that nobody asked any question? How come that nobody asked the question? And you will expect people, within the sector to be familiar with this kind of issues. Nobody asked the question. So those are things that I think we should
interrogate,
to ensure that going forward, we don't have this kind of embarrassment anymore.
And some people are even quick to say that the financial crimes agencies should come in and, that we've gotten these breather, from Justice Knowles or from the UK court, the industrial courts and the rest. Shouldn't the security agencies come in now?
Well, we have a very enlightened and very committed federal Attorney General of the Federation. So it is entirely in his discretion to decide what to do going forward.
And going forward, this kind of contracts, I mean, like we said, of international dimensions that are capable of, going to arbitrations and the rest, how do we tie the knots and, really screw the knots really tight?
No, I think essentially what we should do going forward is ensure that people who are informed are involved in negotiating this kind of contracts. For instance, one thing that I keep asking myself, from the point of signing of that contract up until when arbitration commenced, how come nobody, evaluated or monitored the implementation of the requirements of that contract? How was it possible that nobody asked any question from the point it was signed up until arbitration commenced? How come that nobody asked a question? I mean, usually you see in international contracts, there will be, personnel assigned roles of monitoring, of evaluating the implementation of the contract. How come nobody asked any question up until when arbitration commenced? Because it was so easy to have, to have been detected early on whether implementation was carried out or not. So I think that's an area that perhaps we need to also reflect over and perhaps do some necessary internal adjustments to ensure that.
Isn't it the same problem we're having with the Mambila hydroelectric power generation?
I think the matrix might not exactly be the same, because what my understanding of the P&ID is that from the conception up until arbitration, I'm not sure the intention was to implement it. I'm not, because when you read the judgment from the commercial court and then put it side by side with all that we know in the public space, I'm not sure from the outset that the intention was to implement it. For instance, up until now, I'm not sure there's anywhere you could point to as the proposed site for the plant.
We just know that it was supposed to be in Calabar, in Cross River State,
yes,
and
sir.
the rest.
Yes, sir. Yes,
so
sir.
It was an entire product of fraud, as Justice Knowles said. And you even, raised some critical issues that there were always, if you want to use the word like stop gaps,
yes,
in the implementation of such this thing.
Yes, sir.
What kind of oversight would that have been? And you probably had the the NNPC signature there.
Well,
for such gargantuan, money, should the signing of that contract be left to an organization?
Well, of course, you know that by law, NNPC has the powers to, as an entity of the federal government, to enter into contracts, on behalf of the federal government. But I also do understand that the contractual processes also involves, like the Federal Ministry of Justice, as I understand it, has legal officers or legal directors posted to some of these agencies that oversight them. And also the Ministry of Petroleum Resources also has a legal director, that also, as I understand it, get involved in this kind of processes. So I just thought that perhaps a lot more care should have been taken in ensuring, that some of these things, because if you read through that judgment.
So there's so much complicit, situation here.
Yeah, my view is that we had sufficient red flags along the way, to have alerted us to the danger that we are, going into. Because from the judgment that we saw, it's obvious that we were dealing with a syndicate, international syndicate, and our public officials, with a little bit of attention,
greed,
could have been able to identify some of these things early on.
Yes, one of them got the first payment was about $50,000 into the son's account. Then conclusion of this thing was going to get $500,000. You can imagine, how government officials bring the country down in terms of frittering away its wealth and the rest.
Well, I think
you listen to President Buhari, what he said, $11 billion. That's a third of our foreign reserve.
That's the honest truth. That is the honest truth, and that also, exemplifies the need for us to pay a lot more attention, to our public service and our attitude to, things of this nature. Because, to be honest, from whatever perspective you look at it, that thing could have had a lot of effect on us as a country and also on our economy. So I think the lessons have been learned, and I believe the position taken by government is well informed, And I listened also to the Attorney General of the Federation. I believe that a lot of changes will be made with, ensuring that this kind of thing do not happen going forward.
All right. Finally, let's, look at the entire money spent by the Nigerian government in prosecuting this case. We hear more than $40 million. Is there any way of recovering that money? It's a lot of money. I mean, in today's Nigerian economy.
Yeah. It could be a lot of money, but I mean,
if arbitration, would there be room for that?
Yeah, usually there's a principle in arbitration. We say cause follows the event. Assuming we had expended our money in prosecuting the arbitration and we won, of course the tribunal will allot that cost back to us. But what we have expended the money on is actually on litigation, challenging the award before the commercial court in England. So I'm not sure the same principle
would apply.
Will apply. But it's not unlikely also that we might get a chunk back, but it may not be the entire thing. But for me, aside the money spent, I think we should be interested in the fact that we succeeded in bringing this award down, because it could have been worse. It could have been worse. I mean, what is $40 million compared to $11 billion? It could have been worse.
I agree with you. You're on the same page with the former president, Muhammadu Buhari here, that Nigerians would have, been impoverished if that money wouldn't win that case. Thanks so very much, Dr. Chikwendu. Madumere is a chartered arbitrator, both in England and Nigeria.
Thank you very much, sir.